We're live.
All right, welcome to another day of Judiciary, House Judiciary. We have an aggressive agenda today, committee. However, we are, I think we're going to get through it. We're reviewing a personal bill. The rest are committee bills, one of which is your own that you've seen before. And then the two others will come from select committees on us. So, I feel confident that we're going to be able to get through our work today, committee. With that, Carol, will you please call the roll?
Representative Crago.
Here.
Representative Larson.
Here.
Representative Oakley.
Excused.
Representative Provenza.
Here.
Representative Rodriguez Williams. Here. Vice Chair Washik.
Here.
Representative Yen.
Here.
Representative Zwanitzer.
Here.
Chairman Olson.
Here.
We have 8 here and 1 excused.
Excellent. Committee, just a friendly reminder, it's up to you, but I would light up your mic when you say here, since we are both in the personal and the virtual world, and the people in the virtual world won't hear you. So if you just want to make sure for the people out there watching you that they know you're here, I would do that. All right, with that, let's take up our first bill, House Bill 10, Tribal Reference Amendments. Representative LeBeau from the Select Committee on Tribal Relations. Welcome to the Judiciary Committee, and please take us through your bill.
Thank you, Chairman Olson, members of the committee. Today I bring you House Bill 10 Tribal Reference Amendments. And what this does is corrects and standardize the statutory references from the obsolete name of Joint Business Council of both the Eastern Shoshone and Northern Arapaho tribes to be named the Cooperative Tribal Governing Body or its official successor, Joint Governing Body. And what it also does is corrects and standardizes any statutory references from Wind River Reservation to Wind River Indian Reservation. And it also corrects and standardizes any statutory references to either tribe. So it corrects the word Arapaho by removing the E, and it corrects the word Shoshone by removing the I and replacing it with an E. Those are very important. And so it just corrects that. The bill also repeals the obsolete Wyman Indian Affairs Council that no longer is in existence. So it'll repeal that. And then there's an amendment here. We modified the foreign language references in Title 25 to include the indigenous languages. But we would like to offer this amendment that you guys have a copy before you to strike the addition of or indigenous after foreign in Title 21 and strike out foreign and add world. So the statute would read world languages instead of foreign languages.
And
So
Representative,
yeah.
I believe we were talking about this amendment that you're referencing right now, that was, I think that was intended for the Select Committee to already address, and it just didn't happen. So we're cleaning it up right now.
sure,
That's all.
it
Okay.
wasn't, overlooked on part of the committee.
Thank you.
And that's the bill, pretty much. Any questions? I'll stand for any questions.
That's the bill. Committee questions yet? Committee, it does seem like a voluminous bill, but my understanding of it's the reason behind that is simply the name change that occurs throughout various statutes, and the language changes or the spelling changes that are occurring across statutes. It's voluminous because we're grabbing a bunch of statutes.
That's correct, Chairman.
Representative Oakley, welcome.
Thank you. I'm present. Sorry about that. Apologize to everyone for being late. Thank you, Mr. Chair and Representative LeBeau. I just had a quick language question, wondering if you'd have any preference. And specifically what I'm thinking is in spirit of what we're doing here. So page 3, line 8, and throughout the bill, it says reference to the cooperative tribal governing body means the intertribal council. And I was wondering if perhaps maybe to switch that word to any. And my only thought there is it broadens it a little bit in case they're in the times or when there isn't actually an intertribal council, because I know there are times when that's dissolved and they're two separate. So I was thinking maybe the word any intertribal council, meaning if it exists, and if it doesn't, when we say it seems to say that there is an intertribal council. So just a language thing, just wondering if you have any thoughts on that.
Representative LeBeau.
Chairman Olson, Representative Oakley, could you restate and reread where any would be on line 8, how that would read?
Representative Oakley.
Thank you, Mr. Chair. So on line 8, replacing in the middle there, the word the with any, and again, and I'm asking for your opinion. I don't care, but meaning, so saying, referring to the cooperative tribal governing body means the intertribal council of the Eastern Shoshone and the Northern Arapaho. It would switch it to the cooperative tribal governing body means any intertribal council of the Eastern Shoshone and Northern Arapaho. And the only reason, again, that what I'm thinking is if there are times that an intertribal council doesn't exist, that maybe any opens up a little flexibility. But again, whatever your thoughts are on that is fine.
Representative LeBeau.
Chairman Olson, Representative Oakley, I see your intent and where you're headed with that, but I'm a little concerned because in the bill, I think this corrects it. Even it's going to deal the way the language is presented in the bill currently, the way the amendments that we have, I think is going to cover that. And I see what you're saying. There was a time in the history where we kind of separated, but each tribe is still their sovereign tribes. But there are references in state statute that still identify the joining of that, no matter what. And I think our amendments does it. But we could have a further discussion later if I can talk with our tribal legal counsel. And if there's an amendment and it's friendly, by all means, I understand your intent.
Representative LeBeau, Representative Oakley, so as I'm trying to read this, since the language would maintain intertribal council, implying that there are more than one councils, it wouldn't contemplate, I don't think the change to any, if I'm understanding that right, would contemplate a scenario where you have one tribe, but it would either, whether you have any or it contemplates any successor joint governing body on line 10. So Representative Oakley, I don't understand all of the history here, but it sounds like we're referencing a scenario where there may not be a joint governing body, right? So the issue would also appear, I think, on line 10 then, Representative Oakley, where it says joint governing body.
Mr. Chair, so I think that's fine. If, again, I'm just trying to get at an if, because there are times there hasn't been a joint council. So I'm just trying to make it as inclusive and correct as possible. So, but I don't see any problem there with, or its official successor, again, assuming it exists, is all I'm kind of trying to get. But we can, I think, make sure we feel good about it.
Vice Chairman Washut.
Thank you, Mr. Chairman. I don't think any resolves the issue because it's still referencing an intertribal council. And so any, in my estimation, simply throws it open that some informal arrangement between individual groups between the two tribes might suddenly be recognized in statute. I don't think that's our intent. So I would oppose any amendment to change the word to any.
Well, I don't think there is an amendment, but thank you. Yet.
Mr. Chairman, Representative Washut, I wholeheartedly agree. And then I forgot about that or its successor. So it covers that.
Representative Zwanitzer.
Thanks. Move on to a different question. Can you go to page 25 and 26 of the bill? I'm just a little worried. I want to talk about the historic Shoshone Indian Reservation. And so when we're fixing statutes, and I just know there's been a lot of stuff in the media, so, a US Supreme Court decision on, what's historic when treaties are made and et cetera. Should I be worried at all about why we're putting the word historic in there? And what does that mean differently than the current Shoshone Indian Reservation?
Representative?
That's a good question that you proposed. And Chairman Olson, Representative Swanner, that's a good question. It's very complex. And I don't know if I'm the qualified person to answer this right now and get it to you. But I do know the original treaties included just the Eastern Shoshone tribe, and we came later. We did. We came in 1871. So I'm not the correct person to answer why we did, and I'm sorry, I don't have that answer with me today.
But Mr. Chairman, if asked nicely, you might find it for me by the time it gets to the floor. Thanks.
Representative LeBeau, is there a reason for a July 1 enactment date? In other words, it seems like this could go into effect when the bill is signed into law? Or is there some type of notice, or I don't think there's any rulemaking necessary. Do you know, Representative? Other than they just use the standard July 1 date?
Chairman Olson, great question too. I think it was just on our part as the committee, if I can recollect to the best of my knowledge, it was just the standard date. However, I know anything to do with the Eastern Shoshone tribe, as far as change in legislation, it has to go before their general council. So that could be a possibility, but I'm not 100% sure.
Thank you. Committee, other questions? Anything else we should know?
Chairman Olson, that is it.
All right, we really appreciate it. Thank you, Representative. Who would like to testify on this bill? Oh, surprised.
Thank you, Mr. Chairman, members of the committee. My name is Travis McNiven on behalf of the Northern Arapaho Business Council. Interest of time, you have a busy schedule. I'll be very brief. Certainly the council supports this bill moving forward and thanks the Tribal Relations Committee, Representative LeBeau and the committee for all the hard work in which they have put forward during the interim on this and other bills, and looks forward to continuing to engage on this moving forward. Thank you.
Travis, do you have any information that would be helpful for Representative Swanser's question on historic?
No, Mr. Chairman, I will see if I can also help in answering that.
Right.
And we'll also, I also took note of the conversation between Representative Oakley and on the looking at the language of if there were neither, if the joint didn't sit, if there was maybe some language there too. So thank you very much.
Okay, very helpful. Committee, any other questions? Thanks. Carol, we don't have anyone signed up in the virtual world. Is anyone raising their hand?
No, I don't see any hands raised.
Thank you. Anyone else wishing to testify on this bill? All right, with that, I will close public comment. Committee, what is your pleasure? It's been moved. The bill has been moved by Representative Yin and seconded by Representative Oakley. Amendments on this bill. Representative Yin.
Mr. Chairman, I would move the proposed amendment of changing that language within the bill.
Okay, it's been moved by Representative Yin and seconded by Representative Swanesser. Discussion on this amendment? Question on the amendment. All those in favor signify by saying aye.
Aye.
All those opposed? That amendment is adopted. And Carol, you have a written copy of the amendment, correct? Okay. Any other amendments on this bill? Any further discussion on this bill? Question on this bill? Carol, will you please do a roll call vote on House Bill 10, Tribal Reference Amendments?
Representative Craigo,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit,
Aye.
Representative Yen,
Aye.
Representative Swanesser,
Aye.
Chairman Olson.
Aye.
9 ayes do pass with amendments.
And Representative LeBeau, I assume you will be helping us floor manage this bill. Thank you very much. All right, we will move committee to House Bill 86. Carol, will you please let Richie Englehart into the room? Dave, why don't you come on up? And is there anyone else out in our Zoom world right now?
We have a Terry Armitage
Terry,
that's still
okay.
in the attendees.
All right. Okay. Committee, I will give you a brief introduction of this bill as it comes to you from the Select Committee on Blockchain, Financial Technology, and Digital Innovations. This is a genetic data privacy amendments bill. So a few years ago, I actually sponsored a bill on genetic privacy, and we put in place a statutory scheme for protection of your genetic data when it is provided to a company. So there are a couple of companies out there in the market that we're really talking about. So everyone has a clear reference point. It's simply ancestry.com and 23andMe. There are others, but that is really the lion's share of the market share. And so we put in place a statutory scheme that protects the information that you provide to these companies when you want to opt in and learn more about your genetic data. What we have, these companies return to us, and really they brought us two things. One, they brought us updates to our law that brings our statutes into conformance with their industry practices, which are actually more stringent than our existing statutes. So that's really number one thing that it does is square those. And then number two are simply definitional. So this is really less of a state issue, unfortunately, and more of a federal issue because these are big companies that are operating across state lines. And so what the goal is to try to have as much universality as you can in states, definitional wise. And that is really it. I would say substantively, we maintained as much of our existing statutes as we could, bringing in the thought of conforming definitions across state lines and those industry standards. The biggest part of the industry standards, I'm just trying to recall where exactly it appears in the bill, but basically what it is a series of consents, informed consents checklists, so that when you sign up for something, generally you're online, a checkbox appears in front of you, you agree to terms and conditions. But the industry standard here, and I'm sure the industry will explain it even better to you, is much more detailed than that. There are a series of consents that you give. And so our law really is codifying that process, which we believe is probably one of the best avenues to provide the greatest protection to people signing up for these services. Committee, that's it for the general introduction of the bill. Unless you have any questions for me, I will move to the public, who will probably give you much better insight than I just did. All right, with that, Mr. Pickard.
Oh, thank you, Mr. Chairman, members of the committee. My name is Dave Pickard. I'm representing Ancestry and 23andMe. I'd like to echo the comments that the good chairman made. We brought this kind of these update definitions and best practices to both Chairman Olson and Senator Rothfuss, who were the prime architects of the bill back in 2018. And I had a little bit of activity in 2018 on the Senate side that then the House concurred. And basically what it amounts to is that both of these companies were in their infancy back in that time period and did not have, had not really anticipated the state of Wyoming being a leader in this. And so the companies both want to applaud Chairman Olson and the good senator for kind of their forethought on this and protecting the individual privacy of the customers of these types of vendors out there. So I went through, looked at what the changes that the companies were requesting that they have in many other states. And I think Mr. Engelhardt might share this, but I'll take his thunder from you. Well, what also happened is that in the state of Texas, they were modeling their bill after Wyoming, which we're very proud of, except for the fact that the definitions just didn't comport with what the company practices were, either one of the companies. And so they started looking backwards at where that language came from in 2018 and said, let's take a shot at updating the Wyoming statutes. Let's take a shot at bringing the industry standard definitions to the forefront and adding some additional consumer protections along the way. So that, Mr. Chairman, members of the committee, is kind of the background. And I'm going to turn it over to the expert, Richie. I will say, and I testified in front of the blockchain committee on this, after our initial committee meeting several months ago, I did go out and become a customer of both of these operations. I did not know my background, and I was kind of intrigued. Turns out I'm almost all Scandinavian and a little bit of Wales, which, I really honestly did not know that background. But I did go through all of the consents. And I kind of looked at it from the view of a legislator and trying to protect the consumer out there and to make sure that when I was going through the sign up process, the submission of the sample, and then the receipt of it, and then opting into a lot of these activities that they provide as a vendor, I wanted to make sure that it was very clear, and it was very easy for me to understand all the consents. There's a whole series of them. We went through them one by one with the blockchain committee. Both of the companies put their screen or their process up on the screen. You can go back and look at that. It's very, very transparent, very easy to use for the consumer. And I felt very comfortable in participating in a couple of their additional programs, in addition to just finding out what my ancestry and my Scandinavian descent was. So with that, Mr. Chairman, if there's no questions for me to get into the bill, I'd like to turn it over to Richie.
We will, yeah. And so 1 second, I do want to show this to the committee, Mr. Pickard. So on page 8, committee, if you go to this subsection C, this is what we're talking about, the different types of consent. They're not all informed consent, so I shouldn't say that, but and it says to safeguard the privacy, confidentiality, security, and integrity of a consumer's genetic data, a direct-to-consumer genetic testing company shall, and then continuing over to page 9, you can read through those different, actually all the way over into page 10, you'll see the different types of consents that we're talking about. So I just wanted to point you to that in the bill. You have a question, Representative Rodriguez Williams? Please.
Thank you, Mr. Chairman. Mr. Pickard, just a quick question. I'm just curious, in the event that if either one of these companies were sold to a foreign country, are there any federal laws in place that protect the consumer?
Mr. Chairman,
Pickard.
Representative Rodriguez Williams, I'm going to let Mr. Engelhardt answer that. They work on the international scene, and I think that is within his testimony. Thank you.
Yep. Mr. Vice Chairman Washit.
Thank you, Mr. Chairman. Mr. Picard, I'm just kind of curious that you participated in these research activities of your own ancestry, and you felt comfortable doing so without the statute changes that are being recommended today. So I think that validates that you feel that the consumer protections that are presently exist are adequate. True?
Mr. Pickard.
Yeah, Mr. Chairman, Representative Washit, absolutely. And that goes to really the intent of the legislation itself, is that these are the practices that these companies are engaged in. This is how they operate. And this legislation pretty much mirrors and goes mirrors what they do in practice. And it sets that up, and they believe in the best practices in the consumer protection, and other companies should be doing the same thing if they're in the marketplace.
Yeah, and just to add a little more to that, because back in 2018, when Senator Rothfuss and I worked on this legislation, we didn't have a lens of only what we are calling the direct-to-consumer genetic testing companies. Our lens was anybody and everybody that has your genetic information. So the two biggest companies, we'll call them direct-to-consumer genetic testing companies, are asking to basically codify their practices, which are the industry standard. But I think what you have to think about is the reality that there could be other companies, there could be future companies, there could be individuals as well that have, the entire statute doesn't apply exclusively to direct to consumers, but just as a little bit of a background on that. And then I'm sure, and Mr. Engelhardt, we'll go to you. And just at however you want to start your comments, but definitely to address Representative Rodriguez-Williams's question, because I know that is a question we actually had and vetted during our committee meetings. So I'm sure you'll have some great insight on that. So welcome, Mr. Engelhardt.
Thank you, Mr. Chairman, members of the committee. As noted, my name is Richie Engelhardt. I'm the head of government affairs with Ancestry, and here today on behalf of the Coalition for Genetic Data Protection, which also includes 23andMe. We want to thank you for giving us time to speak this morning about HB 86, the proposed legislation to update the 2018 Wyoming Genetic Information Privacy Act. As Dave noted, a lot has happened since that bill's enactment. Later in 2018, Future Privacy Forum established the privacy best practices for consumer genetic testing services, capping off extensive work with industry partners, consumer and privacy advocates, key committees on the Hill in DC, and the Federal Trade Commission. Since then, other states after Wyoming took an active interest in protecting consumer genetic data, and our companies have worked with lawmakers on both sides of the aisle to translate those best practices into legislation. That bill has enjoyed bipartisan support in Arizona, California, and Utah, with both industry and consumer advocates aligned. As noted before, HB 86 builds on the work that started here in Wyoming in 2018, where the original statute was more focused on consent for obtaining, analyzing, retaining, or disclosing genetic information. The bill before you ensures consumers have access to easy to understand information about companies' privacy policies and more control over how their genetic data is used. And probably the biggest change here is that we define the term express consent, separate express consent, so that the permissions can't be buried in the terms of service. We present the consumer with discrete questions. Do you consent for this? And they have to give an affirmative signal that they do consent. So we get consents before we analyze their sample. We get consents to store their biological sample if they would like to do that. It's not required for them to use the service, but if they're interested in future product offerings or participating in research, we ask them if they'd like to do that. They have to provide consent before they see genetic relatives on our website, and both they have to consent to that and the genetic relative that they're seeing. It's a two-way consent. If both parties don't consent, that match isn't revealed. We also ask them if they want to participate in IRB or Institutional Review Board approved research projects. That's the same governance structure over any clinical trial or human subject research in the US. And again, that's optional. If they want to participate in research, great. If they don't want to participate in research, they can still use our service. And all of those consents are asked separately. So like I said, we can't just bury everything in the terms of service. We also, in our bill, give consumers the power to delete their biological sample if they decided to bank it and later change their mind. They can also change their mind if they decide they no longer want to participate in research or no longer want to see genetic relatives. And then at any time, they can say, you know what? I got what I wanted out of this service. I'm no longer interested. Please close my account and delete all of my data. And they're empowered to do that in this legislation as well. As Mr. Chairman noted, the bill conforms definitions to industry standards and provides us uniformity across the states. If passed, Wyoming's going to have the strongest protections in place for genetic data privacy and statute. And by putting these protections into law, the bill will ensure that every company is held to the same standards. As Dave hinted, you know, Ancestry and 23andMe are kind of the Coke and Pepsi of their direct-to-consumer genetic testing industry, but there are a lot of small startups out there popping up every day online that are compelling consumers to download their results from a service like ours and upload it to theirs. And once that happens, unless there's statute, they can use that data however they want to. So this really does get at protecting consumers from a lot of these kind of pop-up shops that we've been seeing online more and more lately. And before I get to the questions on China, I just wanted to thank Chairman Olson and all of the members of the blockchain committee, because we did a lot of work on this bill in the interim, and we really enjoyed working with everyone and the consideration that was given to this. And as part of those discussions, the issue about what happens when a company is sold, or what are the protections with a foreign entity. So there are a lot of federal laws in place when it comes to the sale of companies. Ancestry just last year was acquired by Blackstone, which is not a Chinese firm. It's actually a private equity firm out of New York. But through that process, we had to go through a CFIUS filing, the Committee on Foreign Investment in the U.S. It's a joint committee of Congress, and they reviewed the transaction before the transaction was allowed to proceed to make sure that the Chinese would not have access to our data. And we had to enter into a letter of agreement with the committee. They are actually coming out to Ancestry next month to make sure that we are in compliance with that agreement. So there are a lot of safeguards in place to make sure that consumer data, genetic data, other forms of intelligence are not accessed by foreign actors, even when a company is sold from one US entity to another. And if we were sold, we would basically go back. All of our agreements with our customers would be in place. If we wanted to change those agreements, because they are part of our terms of service, if we changed our terms of service, we would have to get updated agreements from our consumers to do that. So at no point would there just be a surprise where we were acquired by another company and the terms of service just go out the window. The terms of service are in effect until a consumer agrees to change them. And that's a process that we do annually, even when there's not a sale. So even if we're just updating minor things within the terms of service year over year, we go back to our consumers and get consent that they agree to the new terms of service for the site.
Is that helpful, Representative? Rachel, okay, perfect. Mr. Engelhardt, do you have other comments, or was that was literally your stopping point?
That is all, Mr. Chairman. I kind of tried to work my testimony and the questions all into one, but if there are other questions that the committee has, I'd be happy to answer those.
No, you did it so seamlessly. It was just a perfect stopping point. I just wanted to double check. Okay. Vice Chairman Washington.
Thank you, Mr. Chairman. Mr. Engelhardt, I suspect you're familiar with the Golden State murder case out of California and the utilization of a genetic testing company by law enforcement in that investigation. Is there anything in this statute that would preclude law enforcement from doing an investigation as was done in that Colt case? Does this prevent that type of investigation going forward?
Mr. Engelhardt.
Thank you, Mr. Chairman. Representative Washington, no, it does not. The databases that law enforcement use for that are made available to law enforcement, and the consumers who have genetic data in those databases consent for law enforcement to use their genetic data in order to execute a forensic genealogy search. So Ancestry and 23andMe actually don't let law enforcement into our database. We have a closed loop system that is designed to help people either learn about their family history or learn about, health risks on the 23andMe side. But if our consumers want to participate in law enforcement investigations, they can download their data from either Ancestry or 23andMe and upload it to a site called GEDmatch. And GEDmatch was started by a bunch of genealogy enthusiasts about 15 years ago. The whole point of GEDmatch being, if I do my DNA test with Ancestry and Dave did his with 23andMe and Chairman Olson used Family Tree DNA, we could all upload our results to GEDmatch and see our matches across platform. GEDmatch also set up their site so that law enforcement could enter samples from crime scenes that they knew belonged to the suspect, but they didn't know the identity of that suspect. And when they do that, they basically go in and try and map the family tree and reverse engineer who that person is based on genetic hits from known people in their family tree. Everybody who's in GEDmatch in the database that law enforcement can access has consented to that. And the way that this bill would treat that is that the information has been made publicly available, and therefore there's not a privacy expectation if you say, I'm giving law enforcement access to this in order to do forensic genealogy investigations. So short answer, doesn't change current practice for how law enforcement does those searches. The longer answer is when law enforcement accesses data that belongs to someone who's not suspected of a crime, that person has provided consent for that purpose.
Thank you very much.
And then, Mr. Engelhardt, I don't know if you recall, but or maybe Mr. Pickard, you do, but in our 2018 legislation, we have, I don't have the statute in front of me, but we have a list of exceptions. And there's a law enforcement or court order exception as well. So even under our existing statutory scheme, there is an access point for information. Is that correct, Mr. Engelhardt?
Thank you, Mr. Chairman. It is, and I believe that carries over into this bill because the legislative drafters kept the exceptions from the original 2018 statute when they merged the two bills together, if I'm recalling correctly.
Perfect. Okay. Yep. That's what I was double checking on. Committee, additional questions for Mr. Engelhardt or Mr. Pickard? All right. Thank you both. Any other one signed up in the virtual world who would like to testify on this bill? Go ahead and raise your hands. We can admit you as an attendee. Carol, is there anyone? Okay. How about in the room? Anyone wishing to testify on this bill? All right. That being said, I will close public comment on House Bill 86 and committee. What is your pleasure? Moved by Representative Yin. Seconded by Representative Oakley. Discussion or amendments on this bill? Representatives Wanitzer.
I guess, well, I have three attorneys, so let me ask, and if none of you can help out, I might ask someone in the audience. It's on page 13, and it just seems interesting. So if you have an issue where you want to bring a civil action, the way I'm reading the new language is you have up to 60 days that before you can bring a civil action, you have to notify them of the grievance. They have 60 days to fix whatever violation may have occurred to your satisfaction. If you're not satisfied, then you can file a civil action. That just seems really odd to me. And I don't know if that's standard in any of our other laws, or I just maybe need a little bit of a lesson in jurisprudence on how civil actions work in this regard, and if that's standard or if that's kind of wonky in my mind.
Yeah, I'll take the first little stab at it just because it was Representative Wanser, something that we did look at in the committee. It's a right to cure provision is what it is. So how common it is across Wyoming law, I'll certainly defer to other lawyers to chime in on that, but how how common it is in the existence of our civil system. It is a common process to have a right to cure. What is unique about Wyoming compared to some of the other states, particularly where certainly where in states where high populations of people are affected by these direct to consumer companies, states like, for example, California have a vibrant funded consumer protection division that's going to handle a lot of that. In Wyoming, you can see the Attorney General provision down below, but we don't have the same type of consumer protection division strength that some certain states like California might have. And so, so I'm just bringing that up as a tangent, but somewhat related in that we actually, the committee discussed an entirely separate bill, which we didn't end up sponsoring, that actually probably would have provided a stronger department in that respect. Anyway, as to the right to cure, yeah, it is. And the other thing about this provision, actually, this provision does come to us more in we'll call it the model language or the uniform language that exists in other states, did not exist obviously in our prior statutes. And so that is something that would be more universal across the states as well. I don't know, Representative Yin, if you recall anything else from the testimony on this provision that you would add?
Mr. Chairman, I guess I would just maybe provide an example of something that could happen, right? So I wanted to revoke my express consent for being included in studies, right? So the company would have to go through to those study providers if they weren't doing it themselves, and then request from them. So it's just giving a time period to be able to actually go through that process if that process isn't actually outlined. The curing part we did have a discussion, I think, on what it meant to actually cure, right? So if, for example, the information was published to the world, you can't really cure that by taking it back from the world. So I think it was just to give the chance to be able to handle that before we go through civil action, Mr. Chairman.
Representative Craigo.
Thank you, Mr. Chairman. And just a question for either you or Representative Yin, since you run on the committee. I mean, was there a different timeline discussed? Was 60 days? 60 just seems like a bit long to me. I mean, there are some right to cure provisions in statute. I can think of a couple of them, but most of the ones I can think of are 30 days. I just didn't know if there was a reason 60 was chosen. Representative Yin talked about it briefly, but just was curious if there was more testimony about that.
Representative Craigo, we really didn't. And it's kind of surprising because there are 3 lawyers on the blockchain committee, Senator Nethercott, Representative Stith, and myself. So you think we would have got a little more excited about that, but we didn't. The 60 days came through, again, as just the model language. In terms of whether that's flexible or amendable, I'm sure it is. I don't think anyone was because there wasn't a discussion on 60 days. I don't think anyone was married to it, because going back to Representative Zwanser's question, in Wyoming state law, I don't think you have guideposts that you can really look to that are extremely common, and maybe you could speak more to that.
Thank you, Mr. Chairman. So I'm really thinking of a circumstance where Representative Yin referenced a little bit ago, where you have an unintentional or maybe intentional disclosure at some point, and you're sitting there for 60 days waiting to go file a TRO or injunction of some type, and you're not allowed to do that for 60 days. That's my problem with the language specifically. I don't mind having the right to cure if we could craft some sort of language in there that would give you the right to go at least seek an injunction. Maybe you can't file your monetary damages claim for 60 days, but something in the middle that would still protect the consumer. I don't have the language in my mind, but maybe that's something we could work on between now and in the floor.
Sure. Yeah, I think that's a good idea. But somebody thinks, yeah. put good minds together and look at it. And I think, yeah, we don't have to, absolutely don't have to craft anything on the spot, but certainly open to that amendment. Committee, additional discussion on this bill? No? All right. Well, Carol, will you please do a roll call vote on House Bill 86 genetic data privacy amendments?
Representative Craigo.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams.
Aye.
Vice Chair Washut.
Aye.
Representative Yen.
Aye.
Representative Zwanitzer. Chairman Olson.
Aye.
9 ayes do pass.
All right. Carol, will you call down to House Appropriations and ask for Representative Stith? We're gonna bounce over his bill because it will take him a few minutes to get down from that floor, but just give them a heads up. So we're going to, I don't remember how I had them on the notice. I think I had HB 83 next, but we're gonna skip. Okay, we're gonna skip over that and give Representative Stith some time. And we're gonna go to House Joint Resolution number 1, Supreme Court Justices and District Judge Retirement Committee. This is your bill. Representative Oakley, since you introduced us to this bill on the floor, do you want to just give a brief little reminder to everyone what we have in front of us?
Yes, Mr. Chair, thank you. So as we've discussed now in committee and on the floor, this is a resolution that would propose to amend the Wyoming Constitution, increasing the age requirement at which Supreme Court justices or district court judges are required to retire. In discussing this with the judicial branch, they believe it's appropriate and even necessary to ensure that we can retain our good judges and justices once they are seated. And as we probably all know, plenty of sharp and capable people in their 70s. 70 just seems a little young now to be kicking somebody off the bench when they're doing good service. So our discussion is to raise it 5 years and have the minimum or have the age requirement of mandatory retirement increased to 75.
Excellent. Thank you, Representative Oakley. Representative, oh, do you have a question for Representative Oakley? Go ahead, Vice Chairman Washer.
Thank you, Commissioner. Just to be clear, this would simply put it on the ballot, correct, for a constitutional change. This doesn't actually make the change.
Thank you, Vice Chairman Washut. Yeah, unfortunately, we cannot change the Constitution on our own, but we got lucky because it's a budget session. So we also automatically had to clear the 2/3 vote required by the Constitution to get this bill introduced. So we kind of have an idea when it goes back to the floor. That's also a piece to it. And thank you for that reminder too, Vice Chairman Washut, because committee, if you look to the fiscal note, that's what you'll see is the fiscal impact is from the Secretary of State's office for the expenditure increase of approximately $70,000 for the resolution that you're referencing, Vice Chairman, and the statutory publication costs. Vice, you're not my Vice Chairman.
You can call me whatever you want. Everybody else does.
Representative Zwanitzer.
Thank you, Mr. Chairman. I just want to mention, we saw a similar bill. It's probably been a decade ago. And there was a choice at that time in regard to the constitutional provision that we could take out the age altogether and have the legislature set that number. And so there were legislators who thought that would be better, because once you change the Constitution, it's so difficult to change it again. There are other legislators who believed that the legislature might play some games with certain judges who might be of a certain age and try to change a statute on them, and that negative things could happen if you allowed the legislature to be able to change that age at will, basically, if there were to be an age. So that was the other way to go. We could just take out the age in the Constitution altogether and have the legislature set that through statute. But there was some worry about doing it. That's the way they tried it, I think 10 years ago. Did pass the House and it just didn't make it through the Senate. And it hasn't been brought back since, to my knowledge.
Committee? Any other questions? If not, we'll move to public comment. Oh, one, okay. Vice Chairman Washington, please.
Thank you, Mr. Chairman. Not specific to the resolution, but our circuit court judges are not obligated to retire. And I was just wondering if anybody knew the history of that, how that came to be that our district court and Supreme Court justices need to retire at age 70. But I'm assuming that when we created the circuit courts, there was simply no provision for that included in the statute. But I'm just curious if anybody knows the rationale.
Somebody does. My guess is the circuit court judges are just so insanely busy that we can't let them retire. Representative Craigo?
Thank you, Mr. Chairman. Representative Washington, I believe the reason is because circuit court judges aren't addressed in the Constitution. And so they're statutory created positions. And so there would not have been a need to have the mandatory retirement deadline within the Constitution itself. We could do it by statute anytime we wanted, I think.
All right. Let's go to public comment. Why not invite our third branch of government up? Welcome, Ms. Butler.
Thank you, Mr. Chairman, members of the committee. My name is Elisa Butler. I'm the State Court Administrator at the Wyoming Supreme Court. We are fully in support of this bill. I think you heard the Chief Justice speak about this previously in the interim, and there was some discussion about statutory senility, which the judges generally would say in some, I think, generally 70 is too young. And I think Justice Davis, who recently retired, is a very, very good example of someone who could have stayed on the bench for a number of years after his 70th birthday and contributed substantially to the law of the state. So I think this is a good bill to send to the voters and see if we can get it raised for our Supreme Court justices and district court judges. I would agree with the answer of Representative Craigo, Representative Washit. I will tell you, I believe the Chancery Court, the newly created Chancery Court, does have a statutory age limit, I think. I'm not positive about that, but I think they included it when they created the Chancery Court. I'd have to go look. But that is correct. District courts and Supreme Court are constitutional courts, and the circuit courts are statutory.
Questions for Ms. Butler? Oh, Vice Chairman Washington.
Thank you, Mr. Chairman. Just so I'm clear, if a justice, for example, is in the middle of his or her 8-year term and reaches age 70, do they have to leave exactly on their 70th birthday, or can they finish the term?
Ms. Butler.
Mr. Chairman, Representative Washit, once they hit 70, they are required to retire, even if they're in the middle of their term.
Wonder if statutorily we define birthday. We made reference to foreign nations earlier in the far east of our world. They calculate birthdays very differently. They include gestational period as part of the birthday. So could give you an extra few months. Or take. Well, it depends on how you're looking at it. If you're looking at it as retirement is a blessing. Yeah. See, I thought of that when Representative Zwanser mentioned statutorily addressing the ages and how you could end up with a game of justices. And I wondered if some justices would view adding an extra 5 years as a punishment, but hopefully not.
They can still retire.
They can still retire early. That's true. Thank you, Ms. Butler.
Thank you.
Anyone else wishing to testify on this bill? One of our very own interns. Welcome and thank you. Tell us how you really feel.
Thank you, Mr. Chairman and members of the committee. My name is Grant Baxter, and as stated, I am a current high school intern. So today I'm here just to present some empirical information in regards to HJ 0001. As of February 1st of this year, 32 states in the District of Columbia had mandatory retirement restrictions for judges. Currently, only 18 states, Wyoming being one of them, have a mandatory retirement age of 70 for Supreme Court judges. Of these 32 states and Washington, D.C. That have a forced judge retirement age, the mean compulsory retirement age is 74 and a half years old, thus making Wyoming an outlier by requiring judges to retire at the age of 70. It can also be noted that currently 18 U.S. states do not have any mandatory requirement ages for judges, and they can serve out their time as long as they like. And thank you for your time.
Representative Craigo? Oh, you don't get to run away yet. This is the fun part where we get.
That was a nice
asked
try,
questions.
though.
Representative Craigo?
Mr. Chairman. So I'm just curious if you have statistics on what the average retirement age is in the states that don't have mandatory retirement.
I don't. I just know that they're not required.
Thank you.
Any other questions?
Representatives want to answer?
Is last I knew, I think Vermont was the only state that had one in the I think it's 92.
It's 90 exactly.
Is
Yes,
it
sir.
90 as
Mhm.
the out for any state that does have a requirement. Vermont is the highest that you have to retire at age 90, which I always thought was interesting. And we had a federal judge on the bench until he was 104 last year, which I thought was until he passed. But so the federal judges don't have age requirements either.
Remember that one when we get to the floor. I feel like there's going to be a discussion over the policy question there. Representatives want to answer?
I just, one more quip for the committee. So when this was brought 10 years ago, they actually did a study, and it was more than 25% of the members in the House were over the age of 70. And so that was kind of the joke for the session, that like 18 of the 60 members were past the age of where judges had to retire, and were they still competent to be serving legislators? So I haven't looked at the numbers this year, but maybe the high school interns or college
I
interns.
was just going to ask for that. I feel like we're going to need that average of the ages of the House of Representatives in the Senate. Well, yeah, we would love to have you present that too, but we might have more fun with it. Well, hey, I want to say thank you for coming up and testifying in front of us. Thank you for your willingness to volunteer and serve the state of Wyoming in your capacity. We appreciate that, and I'm sure it's a fun and exciting experience. And we're only a couple of days in, and so, but I really do appreciate your willingness to come up and testify in front of the committee as well. Good. Good to hear. When we get to day 19, you can, we'll revisit that conversation. Anyone else wishing to testify on this bill? All right, I will close public comment. Committee, what is your pleasure?
Move the bill, Mr. Chairman.
Move House Joint Resolution number 1, Representative Zwanitzer, seconded by Representative Oakley. Discussion or amendments on this bill? Now's your chance, yeah. Pick your age, 101 or whatever. No discussion, no amendment on this bill? Oh, Vice Chairman Washington.
I'm just guessing that I'm the senior member of this committee, and I just want to say that 70 doesn't seem as old as it used to.
See, and I'm just thankful that the requirements aren't the reverse, that there's a minimum age to chair this committee, or I'd be out of luck. Representative Craigo, you look very eager to amend this bill or discuss it. Oh, you're ready for the question.
Keep those judges happy.
Carol, will you please do a roll call vote on House Joint Resolution number 1, Supreme Court Justices and District Judges Retirement?
Representative Craigo,
Aye.
Representative Larson,
No.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit,
Aye.
Representative Yen,
Aye.
Representative Zwanitzer.
Aye.
Chairman Olson.
Aye.
8 ayes, 1 no, do pass.
Thank you. Committee, next we will take up House Bill 83, Protection of Parental Rights Application. Representative Stith. I was asked what time we would start this bill and I said 1:15. Yeah. Welcome once again to the House. Just careful, we're still potentially paying for some of that. Go ahead.
Mr. Chairman, members of the committee, thank you. House Bill 83 is a very short bill. And so if you don't mind, I'll just go ahead and read it in its entirety. 14-2-206 is amended by creating a new subsection C, which would read, this section shall apply in any judicial or non-judicial determination or adjudication regarding parental rights involving parentage, neglect, termination of parental rights, child custody and visitation under this title or under Title 20 of the Wyoming statutes. So it's at first glance hard to understand because it says this section. So what is this section? As you know, 14-2-206 was a statute that the legislature adopted in 2017 before my time. And it currently reads, it's also very short. In my understanding of what current statute does is to codify constitutional law about parental rights by stating that the liberty of a parent to the care, custody, and control of their child is a fundamental right that resides first in the parent. Subsection B of existing law is the state or any agency or political subdivision of the state shall not infringe the parental right as provided under this section without demonstrating that the interest of the government as applied to the parent or child is a compelling state interest addressed by the least restrictive means. Fair enough. So simple enough. What happened, as you're aware, in February of 2020, the Wyoming Supreme Court issued an opinion, in the first opinion addressing this statute. And again, I'll just read I think it's worth reading what the Supreme Court said in that opinion. It said, though the statute does not mention courts, Father asserts that district courts are, quote, an arm and agency of the state, unquote, and are thus required to comply with subsection B when imposing custody and visitation schedules that infringe a parent's fundamental right as articulated in subsection A. We disagree. Had the legislature intended courts to comply with section 14-2-206 when awarding visitation and divorce actions, it could and would have said so, but it did not. So that's the purpose of this bill, is to say so. So I'm not sure exactly what the outer scope of the Supreme Court's ruling in that case really means. It either means that the parental rights statutes applies to single parents whose custody would be determined under Title 14, but would not apply to married parents under Title 20. It could mean that. Or the court could be saying that courts don't have to comply with the statute at all because they're not an agency or an arm of the state. And frankly, the opinion's a bit vague about which is which. For purposes of this bill, it doesn't matter. From my point of view, all this bill says is that it makes clear that the fundamental rights of a parent should be treated the same, whether they are married or whether they are single. And that courts have to comply with the law too. So that's all it does. There's perhaps a drafting error in the current draft, in that the way the current draft of House Bill 83 reads, it just says comma, 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 and visitation. And so you can, and it implies that it would only apply to cases where all of those things were true. And so it's never going to be the case that you have both a neglect petition and a parentage and a divorce action going on at the same time in the same case. So to fix that problem, I think there are two ways to fix it. One would be to add the word "or" after the word parental rights on page 2, line 1. The other way to fix it would be to adopt a suggestion of two of my co-sponsors on this bill, Representative Jennings and Senator Hutchings. They had a slightly more lengthy amendment, but that accomplishes the same thing. And I emailed that to you as well as to the judiciary staff. That changes a lot of the words, but doesn't change the intent. It just means that this 14-2-206 would apply to neglect cases or a parentage case or a custody case. So why is any of that important? Okay, why does that matter? Especially, why do we even need this statute at all? Because if all the statute does is codify constitutional law, well, the courts are already supposed to be doing it. So why do we even need the statute? And here's why, although I wasn't here in 2017 when it was adopted, here's why I think the statute is useful. And it's this: when you read courts, state courts, Wyoming state courts, application of the fundamental interest of the parents with respect to custody, neglect, parentage, visitation, usually what the court says is, hey, the best interest of the child is a compelling state interest. And so therefore, mother, father, your constitutional argument just loses, right? And what we care about is just the best interest of the child. And through what appear to be at least a dozen cases from the Supreme Court applying the constitutional principle, to my knowledge, they have never analyzed the second prong of the constitutional test, which is that not only do you have to identify a compelling state interest, but you also have to make sure that whatever you're doing to restrict that parental right has to be by the least restrictive means. And it's the least restrictive means aspect that I think is really important, because, and I think that should apply whether you're talking about a neglect case, whether you're talking about termination of parental rights, or whether you're talking about custody. In termination of parental rights, it's pretty obvious how the least restrictive means prong would be really important, right? Because termination of parental rights is the most severe thing you can do to a parent with respect to their child. In custody cases, the particular, in this case, Johnson versus Johnson in 2020, the issue arose in the terms of whether the father was entitled to a regular visitation or supervised visitation. And in that case, where this statute could have made a difference, maybe it would not have made a difference, is to say, well, is there something less than supervised visitation that would accomplish the best interest of the child? So I think it's important I think the purpose of the statute that I think is important is to, one, tell the courts that yes, the legislature means what it says, and this really does apply to you. And number two, to take this least restrictive means prong of the statutory and constitutional test seriously. So I've probably spoken too much, but Mr. Chairman, I stand for questions.
Representative Yin.
Mr. Chairman, thank you. Representative Stith, so I'm not sure I would have supported the initial bill back in 2017, but I guess my question is, when in this case where the court decided it wasn't falling under the current statute, when the choice is between the least restrictive means and the best interests of the child, were those two different means, while one is more restrictive than the other, was one more in the best interest of the child than the other? So I guess I'm still confused on why this is necessary, even with the wording least restrictive means. So is there a different case maybe, or in this case specifically, where there were two means that were similarly in the best interest for the child, but one was less restrictive than the other?
Representative Stiff.
Mr. Chairman, Representative Yin, I think you've hit on it exactly right, that it's not that least restrictive means would somehow trump the best interest of the child, would trump the state compelling interest. The question rather is, can you achieve the best interest of the child by doing something less restrictive than whatever the government or the court is intending to do, in this case, supervised visitation. So, and reasonable people can disagree about that. But my point is the judge should be considering it because I think often there would be a better solution to supervised visitation if there's no evidence that the children are likely to be harmed. So take the example where you have a father who's not a drug user, not a drinker, has never beat the children, never physically abused them in any way, no allegation of that ever. And the judge says, look, I think you're a misogynist. I think you have a bad attitude. I think you're a really bad parent because you are teaching your children to not like women, for example, right? Well, maybe assuming all that's true, is the least restrictive thing you can do is to say, okay, father, you can't see your children unless you're in a room about this size and the government's watching you, right? So that's how it could have made a difference, in that case, potentially. I don't know. Maybe it wouldn't have made a difference at all, but I think it could make a difference in other cases too. And I think it's important whenever you're tinkering with someone's fundamental rights that you not just focus on the compelling state interest, because there's going to be a compelling state interest in every child case, because the best interest of the child will always be a compelling state interest, always and forever. That's going to be a compelling state interest. But the question is, is this as narrowly tailored as it can possibly be? And from my point of view, it makes good, well, I believe it's constitutional law already that they're supposed to be considering that. The courts just, in fact, have not been considering that. And the statute was intended to force them to, and the judges have said, no, thanks. And I find that really strange. So this is a small fix. Does that answer the question?
Representative Yin, hello, you good? Other questions for Representative Stiff? What's the Supreme Court case? Remind me again that you're referencing.
Johnson versus Johnson. The trial counsel was probably the appellate counsel did a lousy job and lost that case.
Please, Representative Oakley. Yes, please.
Thank you, Mr. Chair. So the case is Johnson that I got from Representative Stith was Johnson v. Johnson 2020 WY 18. And unless I'm reading it, it only applied to the child support. Is that correct, Representative Stith?
Representative Stith.
Mr. Chairman, Title 14 deals with children, right? Title 20 deals with marriage, right? So anything to do with children is in Title 14. Dealing with marriage, you're in Title 20. And the Supreme Court said, well, look, because this was codified in Title 14, it doesn't apply to marriage in Title 20. And that creates the really odd result that married parents have fewer rights than single parents. I think that's really strange. I think that's wrong. And so that's the purpose of the bill, is to level the playing field and say that the fundamental rights of the parent should be considered. And in the marriage or divorce context, it's not just going to be the fundamental rights of one parent, it's going to be the fundamental rights of both. And certainly the child's compelling state interest is going to be a compelling state interest, right? It's just that, and in a divorce case, the court is forced to restrict one parent's access, because obviously if the parents aren't living together, they're not both going to have access to the children 24/7. So there's some inevitable, diminution of your right to take care of your child if you're the non-custodial parent. I mean, I think that's baked into just the fact that you're getting divorced and splitting up, right? Nonetheless, if you're going beyond that, it seems that it's a factor that should be, in my view, should be considered. And I think that it's possible that all the Supreme Court was doing was just saying, hey, the statute's Title 14. We're in a divorce case, Title 20. That's why it doesn't apply. And that may be the narrow reason. I can't really tell the exact scope of what the Supreme Court's intending here.
Representative Provenza.
Thank you, Mr. Chairman. The examples that you give, Representative Stith, are kind of like divorce proceedings, right? And so I'm wondering, how does this play out with, say, CHIN? So children in need of supervision, DFS, juvenile issues, delinquency. Just kind of, can you walk me through that?
Representative Stitt.
Mr. Chairman, Representative Provenza, you raise a great point. So for example, in a neglect case where I've represented a parent where the child's being taken away, has been taken away from the parent, at least on a temporary basis, I have asserted this statute as something the court should consider. And so far, the district judge in that one case where I did that, the district court judge says, yeah, sure, we'll apply the statute, and you lose. Because the child's best interest is a compelling state interest. And I think it does help for the court to say, we're not going to let you be with your child right now. We're going to put them in foster care right now because you are a mess and you need to go to rehab. But the idea being that the court has some obligation to achieve family reunification. The court has some obligation to, when it's interfering with the fundamental liberty interest of the parent, that it's got to do everything it can to protect that interest and make the interference that the state is doing least restrictive. But clearly in neglect cases, and as in the case where I represented the parent, he needed to be in rehab. That child really, that probably the least restrictive thing the court could do is to say, you're not going to see your kid for 6 months, and then we're going to evaluate this. And I think in neglect cases, it's already part of the statute that there's an automatic 6-month review. And I believe in neglect cases. So we already have a process. And I, frankly, from an administrative point of view, I think the Department of Family Services, my experience at least, is that they actually do focus on reunification with the parent when they can, that really is their focus. They're not trying, in my view, this is where my anecdotal prejudice about it is that I don't think Department of Family Services is trying to bust up families necessarily. I think they're trying to unify the families when they can, but also they get reports from law enforcement of children being endangered, for example. So this does apply in neglect cases, but I think that it's already the constitutional law. And so I don't think this really changes that. And I don't think that DFS has any heartburn with the statute. I don't think. I guess you can ask them how they feel about it.
Representative Yan.
Mr. Chairman, thank you. Representative Stith, you used to sit on Judiciary, House Judiciary, correct? And this was a Supreme Court case. Did the interim committee, while you were sitting on it, review this case?
Representative Stith.
Mr. Chairman, this decision came out on February 13th of 2020, which was the last day for the introduction of bills in the House that session. I remember that. Wow. As far as what happened to the interim, I'm not sure. I don't think it was considered during the interim. It was not an approved topic, although there was at least one member of the committee that recommended it be an interim topic. I have a strong recollection of that.
Representative Craigo.
Thank you, Mr. Chairman. Representative Stith. So I just had a question on the language on line 14 of your bill draft. We're talking about non-judicial proceedings. And I mean, in all of our discussions, we're really talking about applying this to the court itself, or courts, excuse me. What's the intent, or what are you trying to capture with the non-judicial determination? Are we talking about arbitrations, or what would we be dealing with there?
Mr. Chairman, Representative Craigo, I believe there are times, and it's referred to in the Supreme Court opinion, where the Department of Family Services will be taking administrative actions of one sort or another, like the decision to remove the child from the home and place the child in foster care, and the Department of Family Services decisions about how to form case plans and things like that. So, but to be honest, my focus and purpose of this has been to make sure it applies to the courts. Were you to delete or non-judicial, I'm not sure that I would have any particular heartburn with that. And you might want to ask DFS if it would affect how they do their jobs. But my focus is not on the administrative piece.
Representative Craigo.
Follow up, Mr. Chairman. So Representative Stith, I was just looking at that I mean, if we're talking about DFS, I would assume they'd fall under subparagraph B already because they are an agency. I mean, there's no dispute about that. I just was curious what if we were talking about some other extrajudicial sort of entity that I wasn't thinking of, but do you agree they would fall under paragraph B?
Mr. Chairman, Representative Craig, yes, definitely as a state agency.
Representative Yin.
Sorry to keep going, Mr. Chairman. So we're in this one case, for example, we had the two choices, right? Supervised or unsupervised child visitation. Who I guess who has the discretion of deciding is one more in favor of the best interests of the child, or whether they're both similar interests of the child, and who has that discretion of saying, okay, so they're both the same and then one's less restrictive? Mr. Chairman.
Representative Sith.
Mr. Chairman, Representative Yen, I believe it's the district court judge, a difficult task in family law cases to make the call as to what's the appropriate remedy. And I think to give kudos to the district court judges. They have a really hard job, and family law cases are really difficult. It's really difficult to get it right. And my purpose here in this bill is not to cast aspersions on the district court judges or how they do their jobs. I just think they should follow the law.
Representative Yin.
So, Mr. Chairman, thank you. As a follow-up, then if they still had that discretion to decide whether which one is more in best interest, would there have been a difference in this case if this law was in place?
Representative Sith.
Mr. Chairman, Representative Yen, I don't know. I really don't. I'm not sure, but I would have liked the judge to have at least considered to say, well, look, I think this person has a bad attitude. This person, may need to be a better parent, and this person has been, say, verbally abusive, in my view, to the children. Would anger management be a better solution? Would counseling be better? Would something other than supervised visitation? And again, this is perhaps not legally relevant, but my anecdotal perception is that fathers in particular, when they're ordered to do supervised visitation, it can have a kind of permanent damaging effect on their relationship with their children. They don't tend to follow through, frankly, as well as mothers do, who are similarly ordered to do supervised visitation. That's just my sort of, I guess, my sexist prejudice about fathers maybe not responding as well to supervised visitation as mothers do. But
Vice Chairman Washington.
Thank you, Mr. Chairman. Representative Stiff, just to follow up on the questioning with Representative Crago. So if we were to delete the words "or non-judicial" from lines 13 and 14 on page 1, do you see that as having a detrimental effect on your bill?
Representative Sith.
Mr. Olson, Representative Washut, if you do that, I would want to maybe add the word "also" in front of "apply." This section shall also apply. That way you don't create the presumption that somehow it no longer applies to the Department of Family Services, for example. I wouldn't want to create an unintended consequence there, but yeah.
Yeah, interesting. Yeah, I think, I don't know, I don't have the statute in front of me to see how lengthy that is, but preference in drafting this bill, one option could have been to include that the existing statutes of under 14.2.206, the existing sections, in order to help guide it. I don't know if you contemplated that, or I don't know if it makes it easier. Suppose it's an amendment option if you're the author of the bill, but I know sometimes it's easier to look at a bill that's referencing to existing statutes to just put it in there. And if you're adding "also," I think you'll just have to answer that question of why "also" is there, but. Thank you. Other Representative Grego.
I can get my button to turn on over here. Sorry, Mr. Chairman. One more question, Representative Stiff, and this might be kind of an off the wall esoteric type question. But I mean, is there some reason we didn't just, if we're going to amend the statute, take paragraph B, for example, and just add the courts of the state as one of the quote unquote entities that to which the statute applies. I'm just wondering if there's some consequence we haven't thought of by creating this new subpart and actually talking about the types of proceedings. Are we limiting or changing law that's elsewhere in the green books by not just putting the courts just specifically within subparagraph B?
Representative Stiff.
Chairman Olson, Representative Craigo, I believe if you, instead of having the current bill draft, you just added the word courts to existing subsection B, I don't think that would solve the problem in my view, because then the judicial branch will just say, well, it's in Title 14. It doesn't apply to Title 20. And then you're left with the problem that married parents have fewer rights than single parents. So I think we need to do something to make to clear that it applies to Title 20 as well.
Representative Craigo.
Sorry, Mr. Chairman, Representative Stiff. So did the case, and I haven't read the case and I apologize, I should have. Did the case specifically say, did the Supreme Court say, hey, this does not apply because we're dealing with Title 20? They used they essentially said that exactly, that we need to essentially reference back in statute to Title 20?
Representative Stiff.
Mr. Chairman, Representative Craigo, yes. With the court it's just a few sentences in the opinion, after saying that had the legislature intended courts to comply with section 14-2-206 when awarding visitation and divorce actions, it could and would have said so, but it did not. Instead, in Title 14, the legislature distinctly prescribes the court's role in, for example, the adjudication of parentage, neglect, and termination, actions in which the Department of Family Services, on behalf of the state, either typically or may participate in accordance with subsection B. Absent any indication that the legislature intended section 14-2-206 to apply to the district court's determination regarding custody and visitation under Title 20, we conclude the district court violated no legal principle and did not abuse its discretion when it imposed supervised visitation without considering 14-2-206. So in my view, the court is specifically saying, because it's not in Title 20, it doesn't count for marriage and divorce actions.
Representative Craigo.
Thank you.
Other questions for Representative Stiff? Anything else, Representative Stiff?
Appreciate your patience. Thank you for considering this. Thank you.
Thank you. Carol, will you please let in Director Schmidt? Okay. Director Schmidt. Director Schmidt, welcome. Thank you.
Thank you, Mr. Chairman. Members of the committee, my name is Corin Schmidt. I'm the Director of the Department of Family Services. I had spoken briefly with Representative Stiff last night and didn't think this really had pertained to us all that much, which is why we are not there in person. However, I do recognize that the committee has had some questions about DFS and the role of Title 14 in the proceedings. Just a few clarifications in response to Representative Craigo's question about B. Yes, Section B applies to the Department of Family Services. In regard to, however, C and the language around non-judicial determination, Representative Stiff mentioned that it would have to do with removal by DFS. And under Wyoming statute, the Department of Family Services does not have authority to remove children or take them into protective custody. That is law enforcement and medical personnel. And then the decision is finalized by the court. Certainly we provide input or recommendations or feedback, but we do not take protective custody. So I don't know what that non-judicial determination would be in terms of a custody arrangement. And then last in our three acts, the Child Protection Act, the Child in Need of Supervisions Act, and the Juvenile Justice Act, the court's already held to a higher standard that meets the threshold of the proposed language anyway. So it wouldn't have any effect on those particular areas, except maybe in times of guardianship where the conversation may have where the state may have to have more evidence and I'm not an attorney, as I said, but certainly more proof or justification for what they would see as the child's best interests. So really no comments on the bill in general, just some clarification of the testimony so far.
Any questions for Director Schmidt? All right. Director, thank you for joining us and for answering some of those questions and concerns that we had. Appreciate it.
You bet. Thank you.
Carol, do we have anyone else in the virtual world? I'm guessing this is where Mr. Terry Armitage would like to weigh in. Oh, was he?
She was the only one.
Or she? I'm sorry.
Corinne was the only one there.
Oh.
The other
Corinne was the
person
only
has left.
Okay, all right, all right. Any other agencies wishing to testify on this bill? You almost became an agency. All right. All right, who's going to testify on this bill? Just raise your hand so I can get an idea. I've got 15 minutes. The committee will need time to take action on this bill. So I'm going to leave 5 remaining minutes for public comment. So raise your hand one more time. So, wow, there are 5 of you, 6 of you, 5.5. You each get a minute. Representative Jennings.
Thank you, Mr. Chairman and committee, for taking this up. Being the author of this original bill, and a number of you were up there have actually voted on this. I just wanted to lend my support to this. Had I known 5 years ago, we would have included this and saved ourselves a lot of trouble. The amendment, I'd also like to lend the support to. It makes sure that we are not narrowing the scope by accident, that we actually are keeping, that we're actually including the courts. And sorry that I didn't catch that 5 years ago. I know it caused you now time-wise, but anyway, stand in support of the amendment and the bill.
My question on that, Representative Jennings, is just, do you have a preference between the 2 amendments? And are you adverse to Representative Smith's suggestion that we just put an "or" on line 1 in front of child custody in between rights?
I don't know that I have, Mr. Chairman, I don't know that I have an aversion to it, but I do think the other one makes it more clear and more likely that we do not accidentally narrow the scope.
And do we have that, committee? Is that emailed to us?
It should have been.
It was? Okay. All right. Thank you, Representative Jennings. Come on up. Yep. Being in the front row is, just keep on coming on up. Lindsay, welcome.
Association. We would like to address the way that we've interpreted the Supreme Court's ruling. And we were going to point out something that Representative Stith did read after the fact, which is instead in Title 14, the legislature does distinctly prescribe the court's role in, and then it proceeds to describe essentially its role in parenting decisions. The reason that from our interpretation, the reason that the Supreme Court relied on Title 14 is because the visitation decision within this court case was because of the children and the welfare of the children. So it was within the court's realm to make that decision. We interpret the Supreme Court case as reaffirming what the district court had decided about child visitation within this case, which supervised visitation was temporary. It was temporary until the father had addressed the concerns with the court, which involved his own anger management and his own counseling. We love that district courts recommend counseling to all members of families, especially during major transitions of divorce. The other thing that the Supreme Court also says in this case is that the district court did do its due diligence in substantiating the abuse that happened to the children within this case, and to the wife in this case, and that happened in front of the children. So the Supreme Court says that really, ultimately, the system worked. And as mental health professionals who sometimes get pulled into this system, we appreciate when the system works. Yes, so our stance really is that this bill doesn't go anywhere. That when it comes to family court, these things are very sticky. There's, as Representative Stith touched on, we have Title 20, we have Title 14, an interim topic we believe would be more appropriate. But at this time, this individual bill, with as fast as the budget session is going, we would like for the Senate or for the House Judiciary Committee to take pause at this time.
Any questions? Lindsay, did you tell us your association?
Yes, I'm with the Wyoming Counseling Association. I couldn't get my mic on, I'm sorry.
That's all right.
Mhm.
All right. Thank you. Next. Welcome.
Mr. Chairman, members of the Judiciary, my name's Sean Octavius Murphy. I'm the founder of Compassion with a K. We advocate for parenting rights, medical cannabis research, and medical freedom. I'm here today because I'm the example of what Representative Stith was talking about. I'm a parent. I've been in litigation for 3.5 years in Colorado. I have a medically fragile, terminally ill child, and it's led to hundreds of thousands of dollars of costs of litigation in Colorado. And I can tell you, if this bill that we're talking about today had been the statute in Colorado, it would have saved all of this fighting, because I know exactly how the courts operate. They take the least restrictive means and apply the best interests of the child, and that's typically done to reduce conflict. So what happens in a case like mine, where we have a child with a terminal brain disease, and the father wants to do something with medical decisions, and the mother wants to do something else? The court will then take the least restrictive means and say, I don't want to create any conflict here. We're going to give the mother the decision-making rights. And that happens time and again in this country, that we have these issues where there is conflict. The courts will step in and apply the best interest standard, and it will flow to the mother. And this statute is needed to protect these fundamental rights for both parents, really. But in many cases, it's the father, because the issue is the court is looking to process these cases as opposed to apply the fundamental rights. So I'm here today because I believe I have a fundamental right to decide what goes in my child's body, not solely decide, but share in that decision. I don't have that decision in Colorado. Same, I feel like I have a fundamental right to make or help make life and death decisions for my child. These are very real for my child, Atlas. We are talking about removing the shunt, being in clinical experimental trials. I have none of those decision rights in Colorado. With this update to this statute, it would have wiped all of those issues out. 3.5 years of litigation. So the one thing I'm asking the committee here to consider is one little inclusion after where it says child custody, to add comma decision making. I think that is critical to point out to the courts that this issue of decision making is a part of the fundamental rights of a parent. And it is very important that the courts see this explicitly, that this is speaking to them. Because again, the idea in a lot of these divorce court matters, child custody, is the courts are looking to process them as opposed to apply heavy judicial understanding. So thank you for listening to that, but this is a very important, I know we don't have many parents here, but I have seen firsthand how important these fundamental rights are, and I am in full and 100% of this bill.
Thank you. Committee questions? We appreciate your testimony and appreciate, well, I think you'll find that Wyoming is a far better place than Colorado in just about every respect.
I'm born and raised here and have moved back from what's been going on there. So thank you all for your time.
Welcome back.
Yes, it's good to be back.
Tara?
Good afternoon, Chairman, committee members. My name is Tara Muir. I am the Public Policy Director for the Wyoming Coalition Against Domestic Violence and Sexual Assault. I work for our network of crisis programs and shelters across our state. Our programs, we talk with hundreds of victims every day. We too were wondering, we're a little wondering what this bill's going to do. However, after 20 years of advocating for victims in my life, I can see a future of very damaging effects in custody and visitation decisions because of a bill like this. I know it's a little queasy to talk about domestic violence, but the court in this Johnson v. Johnson case, and I'll quote the evidence of abuse against the children and the mother. Quote, one of the children, when she was 5 or 6 years old, father pulled her off the top bunk bed, held her with both legs up, and wailed on her in front of her sister until mother intervened. The other case, or the other instance, mother also testified that he shot and killed 3 family pets in front of the children or with the children's knowledge. The other part was mother also testified that he put his hands around her neck and threw her down some flight of stairs. Our big question in this situation is how would this particular bill affect that case at all? And do we really want that court decision changed? I know Representative Stith, this was perhaps very related to his work, but the father was given 2 hours of supervised visitation every other week. And I believe it was ordered to help the children get counseling themselves and he get anger management counseling or some domestic violence intervention. A little education moment, when there's abuse that was evident in this case, domestic violence is not about anger. It's a very measured and calculated slow decline of power and control into a brainwashing of victim and, if necessary, like this case, physical abuse, strangulation, threats. I'll kill you if you leave me. I'll take the kids and you'll never see them again if you leave me. So bottom line of this, custody decisions, as we've heard, are very hard and difficult when parents can end their partnership on friendly grounds. It's when they lawyer up, a party is fearing for their life that things get really difficult. And that's why we have judges. Because I've been doing this for so long, I've heard many a judge come before this committee educating about the need for judicial discretion in these cases. I fear that if we pass a bill like this year, next year, the bill that will come in front of you is to take away discretion from judges and mandate joint custody. Because that seems easier, that seems more fair, but judges, particularly in this kind of case, need discretion. And I don't want to see this building on some kind of mandate in a future year. This case seemed to come out okay for the children. Hopefully everything is still okay for all of them. I'll echo that given this is a budget session, maybe this is an interim study topic once again, and look at that case in more detail instead of rushing it through today, because we only have 2 minutes left because I talked too long. I'm happy to take questions.
Committee questions for Ms. Muir? All right, thank you very much for your comments. Anyone else wishing to testify on this bill? Gail?
Gail Simmons. I am in this case, a private citizen, but I also am a court-appointed special advocate, and I'm on the board of the Compass Center for Families, which is wrapped around court-appointed special advocates. And I want to first express that the main objective of CASA is family reunification. Very specifically, that is our goal. I only wanted to raise a concern in that I'm not seeing a distinction between civil law, the dissolution of a marriage and custody of children as a result of that, and criminal law. So my concern is that having sat through many court hearings and multidisciplinary cases where the parents are provided attorneys. There is a GAL for a guardian ad litem, and the full support of the legal system for all cases is, I just am concerned on how this affects in a criminal case as opposed to civil law, because I think it's very clear that it needs to elevate parental rights in a civil law, because it is easy to take a misogynistic or whatever, but I am concerned about criminal law, and that's it.
Questions, committee? Thank you. All right, with that, I will close public comment. Committee, what is your pleasure on this bill? Moved by Representative Oakley, seconded by Representative Larson. Amendments to this bill, Representative Oakley.
Thank you, Mr. Chair. I would move that on page 2, line 1, remove the comma, add the word or. Insert the word or. Isn't that where? No, that's wrong. I'm going to have Mr. Representative Craigo make the amendment motion.
Representative Grego.
Mr. Chairman, on
Please.
behalf of Representative Oakley, I'll make the
Thank you.
following amendment. Let's start on page 1, line 13. After the word shall, insert the word also. The end of that sentence on line 13, remove or delete the word or. On line 14, delete the word non-judicial. Turning to page 2, line 1. After the word custody, insert a comma. Delete the word and insert the word or.
Well, is that seconded? Second. Seconded by Representative Zwanser. So on the third part of that, so I thought of the exact same thing when Representative Stith was talking, Representative Craigo. The or, so you just struck, you did put an or between custody and visitation, right?
Yes, Mr.
Comma
Chairman.
or, so we're saying, here is the list. It is anything before, anything in this list.
Yes, sir.
Okay. I think, yeah, I think your amendment obviously does more, but I think your amendment and Representative Oakley's amendment would have done the exact same thing with the or. I think that Representative Stith's position was that child custody and visitation is one subject. That's why he wanted the or in front of the subject. It doesn't matter. It accomplishes the same goal in that you don't have to have a suit on everything. Representative Craigo?
So, Mr. Chairman, child custody and visitation don't have to be the same thing. I mean, they don't necessarily have to be determined at the same time or during the same case. And so those can change over time. So I guess if we're going to do this, let's separate them out so that it's very clear that if we're talking about one or the other, we don't have to be talking about both.
That I don't disagree. That's fine. Vice Chairman Washit.
Thank you, Mr. Chairman. Just a question for the bringer of the amendment. We heard testimony from the father from Colorado. Is it your thought that parental rights would include that kind of decision-making question?
Representative Craigo.
Mr. Chairman, Representative Washit. So no, if you go to the bottom of page 1, it's actually termination of parental rights. It's not talking about parental rights in the abstract.
Okay. Further discussion on this amendment? Ready to vote on the amendment? All those in favor of the amendment signify by saying aye.
Aye.
All those opposed? That amendment is adopted. Further amendments on this bill? Further discussion on this bill? Representative Provenza?
Thank you, Mr. Chairman. Just real quick, I would urge the committee to vote no on this and take some more time to consider this bill. We were very careful this interim when we talked about juvenile justice because we knew what the implications were if we did not do well. We asked for data. We looked for ways to fix the system through information that we had. And it sounds like there's some ambiguities today, some confusion. And I'm also inclined to follow the lead of the Wyoming Supreme Court and figure out exactly more why that happens. So I would urge a no vote.
Committee, any other discussion on this bill? All right, Carol, will you please do a roll call vote on House Bill 83, Protection of Parental Rights application?
Representative Craigo,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit,
Aye.
Representative Yen,
No.
Representative Zwanasser, Chairman Olson,
Aye.
7 ayes, 2 noes, do pass with amendments.
Thank you, Carol. All right, House Judiciary, that's it for today. Thank you.